Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London, and today I'm looking at a book which has come to us from Edward Elgar Publishing Limited. It's a family business, independent publisher, and they look at a variety of areas of law as part of their overall portfolio of books, intellectual property being one of the main areas, and this one is on IP. It's intellectual property and general legal principles. It's got a subtitle: Is intellectual property a Lex Specialis? I'll explain that in a minute. It's been edited by Graeme Dinwoodie. Now, Elizabeth and I looked at this book. We had a talk about it, and we've come up for our appreciation with a short title: Some Answers to the Question of Why Intellectual Property Laws Are Special. This book, I would hasten to add, is available as an ebook. It's also part of the ATRIP intellectual property series from Elgar, and it's also online at Elgaronline Law, so it's available electronically. Now, I'll do the review in a minute and explain what we think of the book, but let's look at it first of all. So there's the front. You can see it mentions ATRIP there, intellectual property series, and Graham's name is at there. Then there's the spine, and there's a bit at the back. It's only a light book. It's a hardback. It runs to about 250 odd pages. There's the index starting at the back. Again, just page numbers for the index. Then you've got, after the index, the body copy of the text. There are some quite substantial footnotes again. This is a book that relies very much on substantial research. There, again, you can see, just going through it, there's some subheads and bolder headings all the way through the various chapters. If I go to the front of the book, this is the ATRIP IP series mentioned here, and you've then got, this is the actual book in the series that we're looking at today. There are others obviously mentioned in the series. Then you've got the information about the Elgaronline ebook side there. Then you have the basic content which is set out, and the people who've contributed. As Graeme has edited this, there are 11 actual chapter headings, then the index at the back. Then there's the list of the contributors which are given there. And then Professor Dinwoodie actually starts off with a reasonably interesting, straightforward statement on, in fact, what this book is really all about. And there is, in fact, a bit of a maxim. Part of the maxim: Lex Specialis derogat legae generali. The rule of Lex Specialis typically serves as an interpretive canon to determine which of two completing norms should govern. Now, we'll get into that in a bit more detail in a minute, but you can see the level at which we are starting off. This is not a book for people new to IP, but it's a book that I hope will give some intellectual thought, or actually stir up the intellectual juices just a little bit. There's, again, you can see a lot of the footnoting as we get into particular areas. Then we go on to the main chapters themselves. It's a very interesting book. It looks at the internet, it looks at a whole range of very modern matters. I'm recording this in the middle of 2015 after a general election. We've got a few years of interesting development to take place, certainly in law generally, and IP, I would imagine, will change again. If we go back to the year 2000 and think of what it was like then, and where we are with intellectual property concepts, rights, and what the law is today, and where we're going, you can see that there are some fairly substantial changes that probably will take place within the next 20 years, or certainly 15 years. Now, what do we say about the book? We say this: are intellectual property laws special? This is the key question posed by Dinwoodie, who, as editor of this thought-provoking book, heads what you might call a stellar cast of academic contributors, all from top universities worldwide, from Aberdeen to Exeter to Rome, Munich, Copenhagen and Tokyo, to Osgoode Hall in Canada and Washington University, St. Louis School of Law in the United States, and Professor Dinwoodie himself is Professor of IP and Information Technology, IT, Law at Oxford, I'm abbreviating to save a bit of time, and also Director of the Oxford Intellectual Property Research Centre. So he comes to this with a very substantial portfolio of achievement, and in fact I think we're very lucky to benefit from his knowledge and what he's produced here. Found it a fascinating read. So, laid out for the further enlightenment of IP lawyers and specialist academics everywhere is a choice selection of insight and scholarship on IP, which takes generally a deeper and more analytical look at the subject than one might expect to find in any number of other legal texts. And to this end, the various contributors in the chapters in various ways examine a range of other questions. What, for example, is the relationship between intellectual property and general legal principles? And there's a related question, what is the scope of IP law, and does IP law defy definition? Dinwoodie points out that even though the term intellectual property is defined in the TRIPS agreement, there remains doubt and debate, or rather, about the borders of the concept, let alone its essence. And that's the debate that is obviously continuing. The general aim of these arguments apparently is to rescue IP from being thought of as a narrow field requiring specialist advice only. It isn't that anymore, that's for sure. Exploring, for example, the overlap between IP law and, say, contract law and other areas of law, I was thinking specifically here of tort. The majority of the contributors to this book have sought to analyse the role of IP within broader legal institutions, concluding that, in the editor's word, intellectual property is too significant socially and commercially to be considered only by specialists. In other words, I take that to mean that it's got a much more general application today, and I'm sure that is the case. As for the obvious relationship between intellectual property and contract law, contributor now, Giuseppina, I hope that's pronounced correctly, Giuseppina D'Agostino, and I hope that again is pronounced correctly, of Osgoode Hall Law School, insists that copyright law is inextricably bound to contract law, and that contract law traps the various entitlements that copyright law creates. Referring to this tension between the two, she asserts that identifying copyright's status as specialis vis-à-vis contract law's possible designation as generalis is a lot less important than determining and explaining the relationship of copyright to contract law. Now, of course, you can see what the arguments are in very simple legal principle terms, but you can see how it's been developed here in terms of a specialism rather than a generalism. And it is this hierarchical relationship which most affects creative output in the cultural industries, she says, quote, especially freelance authors, of which I and my wife are two. A more integrative approach is therefore preferable, as without contract law, copyright law has little meaning, because at the end of the day it's an agreement. And is it therefore, if it's an agreement, is it a binding agreement? Is it something you were intending to create a legal relationship about, or is it just that sort of agreement which is a casual one, which has no binding in law? Well, obviously, if it's involving copyright, that's the passing of money and the control of one's ideas and one's concepts, you can see immediately that there must be the intention to create a legal relationship. So it is effectively, as I've always maintained, really, an offshoot of contract and of tort, because it's the problem of, effectively, it's an invasion. I wouldn't say it's not an offence against the person, it's not even really a trespass against the person, but it's a trespass against a right, if you like, when your intellectual properties are infringed. If you look at it say in that way. Let me conclude then by saying that such lucid and concise commentary is typical of the insightful discussions on intellectual property which is to be found in the book. And it's been published, as I say, by Elgar, and it's an important contribution, we feel, to the body of scholarly literature on intellectual property, and a valuable addition to intellectual property and the practitioner's professional library. So you're involved in that area of law, both as an advisor, lawyer, practitioner, or whatever. It's something you really should have. It's a useful, at a high level in terms of the writing style and the content, but it's a useful contribution to the debate. The book's, as I've indicated, also available at Elgaronline and as an ebook, and the publication date is cited at 2015. I'm recording this in the middle of 2015. There's the book again, hardback, brown cover, and you've got quite a lot of detail there. Just opening it in the middle. Inclusivity in intellectual property. Here we go. We've got all the usual current words that are being used. You can see here you've got the footnoting, you've got a little bit of headings, subheadings. You've got, again, this is private ordering and consumer rights in copyright law. Okay. Looking in a lot of detail, again, comparing different jurisdictions, the US, the UK, EU and so forth. Then you've got a whole range of other areas. Intellectual property protection, of great interest, I think, to many people, because people are more aware of their intellectual property rights, I think I could say that reasonably, than they ever have been before. Especially with the advent of IT, information technologies change things, the digital age has changed things. We can take photographs. We've got the current debate talking about taking the photograph of a public building, whether we're going to be allowed to do so in future, because does that infringe a copyright, an intellectual right of any sort, property right? You see, all these arguments are being put in the melting pot, if you like, in 2015 going forward. So these are issues we want to look at, and this book, I think, helps us try to gauge the value of IP. And frankly, it is probably a specialist area in some respects. But there again, your intellectual property rights are very personal to you, so why shouldn't they be special in the first place? Thank you, Professor Dinwoodie, and all your excellent contributors, and also Edward Elgar. Another great book, and it was a pleasure to review it, of course, as it is with most of them. All the best. Bye-bye.